Today, Jira Dr. Afenyo-Markin Abronye abekasa afa Abronye DC ho kyerɛ sɛ ɛkwan a mpanifo afa so handle Abronye DC no enye na de omo as NPP sɛ mpanifo kyerɛ mu sɛ de nti a Abronye omo ma ne bail no ni nyina yɛ sɛ mpanifo no susu sɛ se ma Abronye bail a wanhwɛ na oba abonte a wase abekasa enti until say ye bedi Abronye asɛm ne de ebusua also self-contained na edi amano no Abronye enjoying itself e hotel say court ebeti na asem ebusua yentie Jira Afenyo-Markin
say zaman na kosiri ye hye wa hen de yen bono original chairman a wo friend Abronye a police fo say okaka say ti a judge bi na kaso okaka say kire no was in a court oya hwe wako ogodu court no judge a otne egom na asem nye de se woma Abronye bail a anhwa na wakaka se bio inti was ordinary to fiase ordinary to prison until they wo bezi asem na wi na won breme no se won bu ufo a intu monko wia efiase na judge na asem na ranke wi nanso edikan ezinyimpa na akoto remand ona make dikan kade woya ye Supreme Court oye onyimnyamfo Martin Pebu oye lawyer Mbribi abasin Condemns nsami wo ma bail wo ba ma bail wo ma bail wo ba ma bail onunti ozasam ko free court ama Supreme Court ka say kade debi bail ze unyiya de oye de was manyimpa osande until de nyimpa no wo bezi na asem ewe bu no fon intum nka de edine court fiaze na za punish inti bail asem zo ya za waka wasam that the court ibio ye wo offenses bi obaka de odama bonize nanu yesho ene ye wo za bronyi kade mizemina ochada oye bibi kitikiti bia onya za oye hu na za wose Abronye akoye okadama mizemina ayi embrano hu inti sadamu mpo a ebazi ntino de judge kade ozne ko to prison ozi kan kade ozne ko nsawom ansana ibi o kade ozne ko ayi bna fitida omani ruling there ozne ko to remand nan court order mpo onto me sign meanwhile court dem one onye manual court or your digital court erika se nyina no will type into within 5 minutes after proceedings or there at least clerk or to print judge why is serious when edwuma within 5 minutes or do to kan nan ruling no na o sign as a defeated nyumbri na nankasa no ruling pon sign into questioner NPP fie bi saying there BNI fo was it Abronye call one channel eba krata no zechi police fo no so was it Abronye crop BNI eba krata na was ye ngina do ana anu keke na was ken no onu nti yan kase ni wie yanyi de o man pay mahama inyo bia no nya second chance presidency inyo bia no nya second chance adum keke into man pay mahama yesre aka onfi beye ebie nafa na ze wedwuma abewe yi nyankopon na adom ma woso asom woman for them 8 years na oda wakomado inti jewechiriye omanpai mahama ya sam nyi de jewechiriye na ochina wo fa bibi to ho a ochina bi nyi ho a Ghana wo bobo wuzin was akasa na bia na efo na judges na police fo no enziye bia wo yen se ma wanyon ko ho se nyim ho hwea ma wanyon ko ho omanpai mahama yenuanum so wo NDC mo onye hon daw de ende oye NPP ni na ochina wo ho na no otumfo se embre ni zen emimenti twi no mezenye fante
America so
otumfo ose embre eni nkaso enti yenuanum a wo parliament oye NDC fo parliament boye ya woda Yebo someone in minority. Yebo someone BNI Director General. IGP. No only Chief Justice. The judge na all ya damazin yam shene yan kanwasam. Abronye na asam no yanda wo ho. Ena wana wo invoke them section 207 and 208 ne pede ya kanwasam. Yesre ye nuanom NDC for our parliament. One boa na yemfa ye into ye. Dem brebe ye ochine bi abebi ba. Na someone so wo opposition. Na wo di wana asam ya ye a otedama. We tum we use mbra no na was agye won fa hozi. Na se wo ya wadwen there business as usual. Wo ya politics into wo man yen kon because they have 2/3. Enyanze yenyi tum yabaka na was one numbers or they win vote. But one came with there so one support him. Na yentum yamfa nzama ntu ye ya. Ochine bi na power bi aba. Because already they are on their way out. Why won him? The 2028 will lose one won him. Until him they will lose election 2028. Then him there President Mahama on baby as Nejuma Beneri. It is your own interest. The injustice be a and then able to tune ye am watching be a minister neko one jima. I assured there and brave your wa over protector. Nasa wanyana dama honors a wara. Thank you for responding to our invitation upon a very short notice. This evening, I am privileged to have been nominated by the party to address you on this all-important matter. One of our own, Kwame Bafo Abronye, has been arrested, remanded by a court, which is supposed to be a court of justice under normal circumstances. The party considers this a constitutional outrage. The arrest itself, the so-called prosecution, and the remand. But before I set in motion the submission of the party expressing its view on this disturbing matter, let me refer to the 2015-2016 One Supreme Court of Ghana Law Report, specifically at page 175 in the matter of Martin Kpebu number 2 versus the Attorney General number 2 in writ number J1/13/2025. This reported case was delivered on 5th May 2016. I shall rely on the general view of the courts in their declaration. Quote, Article 19C has given a suspect under investigation or an accused on trial the benefit that he was innocent until the court had found him guilty after a hearing or following a plea of guilty. The grant of bail was one of the tools available to the court to ensure that a suspect or an accused, as the case might be, was guaranteed his innocence until the court had found him guilty. The presumption of innocence in terms of Article 19(2)(c) of the Constitution embodied freedom from arbitrary detention and also served as a safeguard against punishment before conviction. It also served as a preventive measure against the state from successfully employing its vast resources to cause greater damage to a person who has not been convicted than he could inflict on the community. Therefore, any legislation outside the Constitution, such as Section 96(7) of Act 30 as amended, that took away or purported to take away, either expressly or by necessary implication, the right of an accused to be considered for bail would have prejudged, presumed him guilty, even before the court had said so. That would be clearly contrary to the letter and spirit of Article 19(2)(c), which has guaranteed his innocence until otherwise declared by a court of competent jurisdiction. JSC, who was part of the majority at page 176 of the law report, said in these veritable words, which I quote, Article 19(2)(c) of the Constitution takes precedence in the laws of Ghana, and any law found to be inconsistent to this constitutional provision must, on the basis of Article 21A and 131B of the Constitution of 1992, give way and be declared inconsistent and in contravention of the Constitution 1992. In my opinion, Section 96(7) of Act 30 as amended is one such legislation that is inconsistent with the Constitution. The general tenor of Section 96 of Act 30, which deals with grant of bail in general, therefore gives very clear indications. On the whole, the courts have a discretion to grant bail to persons appearing before them in criminal cases upon conditions stated therein. The absence of grant of bail in Section 96(7) is therefore odd and unnecessary interference with the discretion of the courts. The lead judgment of the court delivered by my brother Benin JSC, striking down 96(7) of Act 30 as amended as unconstitutional, in which I concur, is not a carte blanche for the court to admit every Tom, Dick, and Harry to bail pending trial, because the removal of the statutory shackles in the impugned Section 96(7) of Criminal Code Offences Act 1960, Act 30. On the strength of these, I set in motion the concerns of the party in respect of the remand of Kwame Bafo Abronye, our Bono regional chairman. Yes, yes, my baby, that's it.